President Trump's judicial nominees going viral for the wrong reasons as Trump comes under fire for his nominees' qualifications.
The law was enacted in response to the mass killing of 7 people at a 2022 parade in Highland Park.
Do you know what a motion in limine is?
I would probably not be able to give you a good definition right here at the table.
Now keep in mind, it comes after a federal appeals court blocked it again over the weekend.
Tell me what Article 5 of the Constitution does.
But that he and the Attorney General's office will continue to fight in court to make sure this full bill can be implemented.
Basic question about Constitution. Senator John Kennedy's fundamental inquiries concerning the Constitution seemed to stump President Joe Biden's judicial nominee on Wednesday during her Senate confirmation hearing. When Kennedy, R-LA, pressed Spokane County Superior Court Judge Charnel Bjorkengren about articles of the nation's founding document, she was unable to respond. Bjorkengren was nominated to be a U.S. District Judge for the Eastern District of Washington. Kennedy started his line of questions with, "Tell me what Article 5 of the Constitution does." At this time, I'm not recalling Article 5, Bjorkengren answered. "How about Article 2? Inquired Kennedy. In response, Bjorkengren said that she also hadn't thought about that.
Tell me what Article 5 of the Constitution does.
President Trump's judicial nominees going viral for the wrong reasons as Trump comes under fire for his nominees' qualifications.
Article 5 is not coming to mind at the moment.
Okay. How about Article 2?
I'm an eternal optimist, but I am also a committed realist.
The method for modifying the founding charter is delineated in Article 5 of the Constitution, whereas Article 2 delineates the administrative powers assigned to the President of the United States. Kennedy next questioned Bjorkengren about her knowledge of purposivism, which is an interpretation of statutory law that, according to Legal Theory blog, maintains that the legal effect of a statute should be determined by the objective purpose of the statute. Bjorkengren was likewise ignorant of the concept of purposivism. She remarked, "I was not faced with that exact question in my 12 years as an assistant attorney general or in my 9 years as a judge." Kennedy's tough interrogation of prospective judges has prevented a nomination from being confirmed previously. In 2017, after an embarrassing exchange with Kennedy that went viral, Matthew Peterson, a lawyer and former chairman of the Federal Election Commission, withdrew from nomination to serve on the U.S. District Court for the District of Columbia, which was nominated by then-President Donald Trump.
Have any of you not tried a case to verdict in a courtroom? Do you know what a motion in limine is?
I would probably not be able to give you a good definition right here at the table.
About his experience, admitting he has never actually tried a case in court, and it just went downhill from there.
Have you ever tried a jury trial?
I have not.
Civil?
No.
Criminal?
No.
Kennedy's fundamental legal inquiries were also beyond the knowledge of Peterson, who had never tried a case. Some of these nominees that have been forced in the last 2 years have no business being anywhere near a federal bench. They don't have any business being anywhere near a park bench. Kennedy said to NBC News following the hearing, "I don't ask the nominees, do you support this president or that president?" He continued, "I ask them to explain the law, what the Constitution states, and how our administrative institutions and the federal judiciary work together. All of these queries are quite fundamental." Concealed carry law on hold. Arm owners in California will likely be allowed to carry their firearms in most public places until this summer, if not longer, now that a federal appeals court panel has blocked central provisions of a state law that ban carrying arms in schools, parks, libraries, and other areas the law classified as sensitive. While the 2 judges on the 9th U.S. Circuit Court of Appeals who issued Saturday's order did not state their reasons, their decision to halt enforcement of the law, SB 2, indicated that they believed it was probably unconstitutional, under standards set by the Supreme Court in 2022. The law will remain on hold until the two judges, joined by a third panel member, hear the case in April and issue a ruling, perhaps within a month or two. And if the ruling goes the same way as the panel's order, SB 2 will remain unenforced unless a majority of the 29-judge appeals court grants a new hearing before an 11-judge panel, which would then decide whether to let the law take effect. The judges did not identify themselves, under the court's policy to withhold the names of the panel members hearing a case until shortly before the hearing. Chuck Mitchell, founder and director of the National Rifle Association's California affiliate and attorney for armed advocates who sued to overturn SB 2, said Monday he is confident that the law will remain on hold, at least for much of this year. The politician's ploy to get around the Second Amendment has been stopped for now. California had a law like New York's, but replaced it with SB 2 by Senator Anthony Portantino, De La Cañada, Flint Ridge, Los Angeles County, which was due to take effect this month. But U.S. District Judge Cormac Carney of Santa Ana issued an injunction December 20th that blocked a central provision of SB 2, its ban on possessing arms in 26 locations that it defined as sensitive places.
California law banning concealed handguns in most public places got a lot of attention. It's been blocked again in court.
But that he and the Attorney General's office will continue to fight in court to make sure this full bill can be implemented.
Bans people from carrying concealed guns in 26 types of places, from parks to churches to banks.
Tracking a new challenge to a California law banning concealed carry in many public places.
They included schools, libraries, parks, banks, public transit, any place where alcohol is sold and other businesses or property, unless the owner expressly agrees to allow firearms. Carney noted that arm owners in California must be adults. SB 2 raised the minimum age from 18 to 21, a change that has taken effect, and must also take a training course and pass an exam on arm laws and safety measures, as well as a background check when they purchase an arm. He said that the state law violates the Supreme Court standards and requires law-abiding arm owners to open themselves up for slaughter at the hands of people, flouting the law. On December 30th, a 3-judge 9th Circuit panel granted Attorney General Rob Bonta a stay that allowed SB 2 to take effect 2 days later. But under standard court procedures, the case was then overturned to the panel that will hear Bonta's appeal in April. A week later, it lifted the stay and allowed open carry to resume with few restrictions. Illinois assault weapons ban. The Supreme Court refused, again, to block Illinois' ban on assault weapons and high-capacity mags. An arm rights group and arm shop owner argued the bans violate their Second Amendment rights and asked the justices to step in on an emergency basis to block enforcement. The plaintiffs made a similar request in the spring, which was rejected. In a brief order with no noted dissents, the High Court again rejected their motion. The decision leaves in place the laws, for now, although the issue could ultimately return to the justices. Illinois Democrats passed the arm control measures following a mass slaying at a 4th of July parade in Highland Park 3, which slayed 7 people while wounding dozens of others.
The law was enacted in response to the mass killing of 7 people at a 2022 parade in Highland Park.
A federal appeals court rejected that lawsuit, allowing the State Rifle Association to appeal to the Supreme Court.
Trying to put a hold on new Illinois law that would ban high-power semi-automatic weapons.
Challenge to the state ban on assault weapons. The Illinois State Rifle Association has filed an appeal with the U.S. Supreme Court.
In Naperville, a city located about 35 miles southwest of Highland Park, officials there passed a similar ordinance that bans the sale of assault rifles, defined to include 26 categories of weapon or other firearms that meet certain criteria. But the plaintiffs, the National Association for Arm Rights, along with Robert Beavis and his firearms store, Law, Weapons, and Supply contend the laws violate the Supreme Court's new test for assessing Second Amendment violations. In the landmark decision last year, the High Court's 6 conservative justices ruled that arm control measures must be consistent with the nation's historical tradition of firearm regulation. A federal district judge in a preliminary ruling declined to block either the state law or the city ordinance in February. Last month, a 3-judge panel on the 7th U.S. Circuit Court of Appeals affirmed the ruling. The plaintiffs then asked the Supreme Court to temporarily block the new laws as the appeals process continues. In summary, the 7th Circuit's decision was manifestly erroneous, the plaintiffs wrote in court filings. In the meantime, plaintiffs and hundreds of thousands of law-abiding Illinois citizens are suffering irreparable injury because their fundamental right to keep and bear arms is being infringed.
On Tuesday, a new bill was signed into law that outlaws the sale and manufacturing of semi-automatic weapons.
Now, keep in mind, it comes after a federal appeals court blocked it again over the weekend.
Illinois responded in court papers by arguing the plaintiffs did not satisfy the Supreme Court's high criteria for emergency relief. Applicants' request, which was not made by any other plaintiff in the 6 cases consolidated below, should be denied for essentially the same reasons that the court denied their application in May. The state wrote, "The Supreme Court has declined multiple emergency requests to block arm control measures since handling down their landmark expansion of Second Amendment rights last year." On their normal docket, the justices are currently weighing a case challenging a federal law criminalizing arm possession for people under restraining orders. The decision in that case, which is expected by the end of June, could clarify the court's test. That's all for this video, folks. See you next time.